And thank you for joining us here on PM Express. It's a Monday, and the Supreme Court is subject of some further scrutiny again. And there are two issues that has been agitating people's minds. You may have seen this raging controversy since that landmark Supreme Court verdict that says the Deputy Speaker of Parliament can vote whilst he's presiding. Well, now we understand that the man who first took this matter to the Supreme Court has filed for a review of that decision. We'll talk about that mainly. And then you've heard the National Security Minister also speaking to judges, make some pronouncements that in itself is raising some questions. I mean, his comments has largely been criticized by members of his own party and his government, indeed. We've heard today from the chairman of the NPP legal team suggest that Kanda Parr's comments that when judgment from the courts appear to be skewed towards them, as in the ruling party or the government, it gives the impression of bias about the courts and the judicial system, and that has been criticized. Later on, I'll ask my guests what they make of that comment by the National Security Minister. We're speaking in the context of national security, by the way. But let's focus for a second on this very important action that Justice Abdullahi had decided to embark on at the Supreme Court on the back of a unanimous decision. That's a hurdle he has to cross. And he's filed this case asking for a review of the Supreme Court decision on the basis of miscarriage of justice, he argues. And then he lays out his case fundamentally. And the Supreme Court ruling on the 9th of March made three fundamental, profound judgments. Well-reasoned, if you read it. Well-reasoned, thorough, very well researched. Many were convinced by it at the time, including myself, I must admit. But Justice Abdullahi believes fundamentally that there's been a miscarriage of justice and he wants to challenge that. We'll come to his basis very shortly. But these are the three decisions that the Supreme Court reached. One, that the Deputy Speaker could himself vote for purposes of quorum, can vote and maintains his original vote. Also, that the Order 1093 of the standing orders, they struck that out because it is inconsistent with the Constitution, because it takes away the acting Speaker's powers of voting, right? And then approval of the budget and economic policy of the 2022 was, the Supreme Court held that was valid, because, of course, if they held that the Speaker, the Deputy Speaker, can indeed vote while presiding, and he did so in approving the budget, then, of course, that decision stood. So three decisions, and Justice Abdullahi has gone to the Supreme Court challenging this. Now, these are the grounds that he's gone to the Supreme Court with. One, that the exceptional circumstances which have resulted in miscarriage of justice. These are the basis. You can't go to court, right? You can't go to court to challenge a decision of the Supreme Court, especially in the case where, like this, which is very unanimous, unless you can prove some of these ingredients. One of the first ingredients is that there must be exceptional circumstances which have resulted in a miscarriage of justice. That is why I stated earlier that Justice Abdullahi believes there has been this miscarriage of justice. And then second, ground that you must have to prove in court that you've discovered some new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. He says he's found something like this that he's going to bring before the court. Now, according to Justice Abdullahi, and this is some of the key things he's bringing out, the ordinary bench failed to consider legislative antecedents when he held that the Deputy Speaker has an original vote. And he cites this clause here. This is what the Supreme Court said, that it's our humble submission that the ordinary bench of the court overlooked on considerations of legislative antecedents and then to Constitution. This is his point that he emphasizes. And he cites the relevant clauses to back his argument. This clause says, any other person, including the Deputy Speaker, shall, when presiding in the Assembly, have an original vote but no casting vote. He's pointing this out, and he will have to make this point before the court. Again, he makes the point the Speaker shall have neither an original nor a casting vote, but any other person presiding, including a Deputy Speaker, shall have an original vote but no casting vote. He's citing constitutional and legal provisions to back his point here, which is what is before the court. We'll get him to explain fundamentally what all these mean to his case and the potential success of his case very shortly. It's clear from Article 80 of the Constitution, 82 of the 19th Constitution, an article, he mentions a lot of these articles, that a person presiding in Parliament is expressly excluded when determining a quorum of Parliament. So he's going back to make these profound cases. And if you see the clauses in question, he will have to resort to the fundamental 104, which is one of the most contested issues or contested provisions of the Constitution recently. It's going to be front and center again when this goes to trial for a review at the Supreme Court. Well, he's going to join me very shortly for a conversation and other legal minds also. But I want to also throw in at the end the comment by the National Security Minister, which ties into all this, because he had said that when the court appears to be ruling consistently in the favor of the government or the power of the ruling party, then it creates a certain perception of bias. I wonder what my guests say about that. When we return from the break, we're going to get into that conversation. Stay with me. And thank you very much for joining us here on PM Express. You've seen the basis for this conversation, a very interesting one about the judiciary, largely the Supreme Court. Let's bring in my guest now. Justice Abdullahi, a plaintiff and applicant. Also joining me is Inusa Fuseni. He's a former member of Parliament. He's a lawyer himself, and he was a ranking on the Constitutional Legal Affairs Committee. Martin Kpebu, it's been a while since I had him on the show. I'm grateful that he could join me on this matter. Martin, I'm grateful that I could have you on the show. As for Inusa Fuseni, he's my partner in democratic activism. You know, he knows what I'm talking about. Thank you, Mr. Fuseni, for your time on PM Express.
Thank you.
Let me start with you, Justice Abdullahi. You have summoned all of us to this conversation because you decided to take a matter first to the Supreme Court earlier this year, which has generated one of the most controversial, decisions, I guess, very, very fundamental to the way we do our business in Parliament, our democracy. And you've gone back for a review. This is a unanimous decision. I mean, give us a sense broadly of what has convinced you to take this case back.
Evans, good evening. It appears that I'm the only guest here, and so as custom demands, I would have to greet my senior brother Inusa Fuseni, and indeed Martin, who is my very good friend and a brother as well, and almost a neighbor now. So. Since having said that, Evans, I need to point out that indeed I am more fortified to go for this review, considering the plethora of materials that are provided in my application. If you've noticed it, some of which I saw you catalog just before the show commenced. I feel strongly on my position that, considering the judicial antecedents to our present circumstances, we had a lot of information that could have guided all of us, myself, the Attorney General, and the Supreme Court, for that matter, in coming up with the decision that they came up with. I think because we are all bereft with those litany of information is the basis for the decision that resulted on the 9th of March. And I think that having a second look at that decision would inure to the benefit of all of us as Ghanaians in particular. Okay.
So break it down for me, because I want my other guests to join in conversation. So what is it? What are these issues that convinces you that you have a shot at getting this review?
Yeah, first of all, you will notice that, as I indicated, if you go through the antecedents, you will notice few things. In fact, let me start from the beginning. You notice that from day one in 1957, when we started, we had Act 300, which is still an act that is applicable to even up to date, which provided for the presiding officer having an original vote. So we started with this idea of a presiding officer. The presiding officer excludes the speaker himself, that is his deputies. They had an original vote. This continued for a while until it was repealed by the NRC regime. And then that repeal was also further repealed by the NLC. And so from that moment, we've had this phase of our lives where the original voting rights of our deputies have consistently been taken away after the overthrow of the Nkrumah regime. Now, having come to that point, you have never had any serious attempt. There has never been any provision really providing for this area of our life. Now, you come to our present 1992 Constitution. I mean, traveling all the way to this point. You come to the 1992 Constitution. The 1992 Constitution allows Parliament to provide for any form of lacuna identified in the Constitution. It is easier to call it lacuna, but it's actually a position where, per our laws, whenever there is that kind of vacuum where laws have not been provided for, the Constitution allows Parliament to provide for that vacuum. As a matter of fact, if you read the Constitutive Assembly's report, initially they included the president, so the president could have also made provisions for areas of the law that they felt or he feels that have not been taken care of. But they took him out. Now, leaving Parliament as the only authority to fill in these gaps. Now, the reason why this is very important is because, as I've indicated, right from the time when the Section 14 was taken out from Act 300, what you've noticed is that nothing has been provided for in the area of the voting rights or otherwise of the Deputy Speaker. What that means is that Parliament is the only authority that can provide for that, because the Constitution doesn't provide for that at all. The Constitution is completely silent over it. So as to whether the deputy can vote or not is not provided for, which is why, in my belief, Parliament, through the standing orders, provided for this by taking it away from the deputies. That is the provision that has been struck out. That is Order 109 Clause 3. Now, perhaps my thinking is that perhaps if Parliament wanted to do it better, they probably would have done it by an enactment, either by amending Act 300 and provide for that, so that the original repeal would now be restored. But instead, they didn't do it that way. They provided for it through the standing orders. We are not saying in any way that the Supreme Court cannot take away or strike down any legislation. The Supreme Court, if they feel that a particular provision is inconsistent with the Constitution, they have every authority to strike it down. However, I am saying that notwithstanding that overwhelming authority of the Supreme Court to strike down any legislation, this particular area was not an area that, to my belief, is inconsistent with the Constitution, because the Constitution does not provide expressly for it. And so Parliament, with that reserved authority to provide for this area, provided for it, but only through a standing order, not through a substantive legislation. And as far as I'm concerned, with this having been done and taking away that right that was originally reserved for the presiding officers, but which was subsequently taken away through the NLCs and NRC, we cannot, through these pieces of legislation, say in any way that per our Constitution, the Speaker has that right to vote, when in actual fact, clear provisions have been made, taking it away from these persons, occupants of these offices. And remember, it is only taken away so long as they exercise their authority as presiding officers, not when they are exercising their functions as members of Parliament. So, in other words, it's just what you may probably call a reserved authority, sort of. So until they exercise the office of the Speaker, they still have their power to vote and be counted as members of Parliament and all of that. So it is not accurate when it is put as if their right to represent their constituents have been taken away. It is not at all. And we should all remember that, as I kept saying, that really it is by virtue of the secondary office that they occupy that these rights have been taken away. And it's the same way, if you want to appreciate this better, look at it from this angle. members of parliament ordinarily can be ministers of state. But the moment you become a deputy speaker, you are deprived of this right to become a minister of state. Now, the reason is very simple. Because the moment you become a deputy speaker of parliament, you are no longer an ordinary member of parliament. And the constitution says it's so clear under, I think, Article 297H. It provides so clear that the moment you are referred to, in fact, and let me quote it, it says that words directing or empowering a public officer to do an act or thing, or otherwise applying to him by the designation of his office, include his successors in office and all his deputies and assistants. Now, the implication of this is that when referring to a person and a public officer, his deputies or any person acting in that office are one and the same. So in other words, they have the same authority, they have the same powers, they have the same literally everything. And it's best words when you move on to Article 2952 clause 2, I think, yeah, 295 clause 2. It deepens this particular position that I've just read out under Article 297. When it says that a reference to the holder of an office by the term designating his office shall, unless the context otherwise required, be construed as including a reference to the person for the time being lawfully acting or performing the functions of that office. Now, the combination of these two provisions make the office of the speaker and his deputies, as far as the constitution is concerned, one and the same.
Okay.
Which is why, as I indicated earlier, that person is unable to occupy any position of any ministerial position. Okay. It is the reason why he is unable to occupy a ministerial position. Now, if that person cannot occupy a ministerial position, then under what circumstances would you say that he's half a deputy speaker?
Okay, stay with me. So fundamentally, we get the gist of where your inspiration is for the review. Let me bring in Nusa. Nusa, you were in Parliament for so long. We all debated the judgment. Now he has found the basis for a review. You've heard his argument. What do you think?
Well, thank you, Evans, my partner in democratic activism. Yeah, that is... it's quite encouraging. I mean, what Justice Abdullah is trying to do is to invoke the jurisdiction of the Supreme Court under Article 133. That is the review jurisdiction of the Supreme Court to look at certain matters that have come to his attention, which matters are exceptional in the circumstances, and which, if not corrected, could lead to a miscarriage of justice. Clearly, the review jurisdiction is not invoked lightly. And so you have to satisfy the court that there are exceptional circumstances, really and indeed. And we have to wait until he goes. I mean, the Supreme Court has listed this matter to come off on the 26th or so of April. If indeed they sit on the matter on the 26th of April, whether they will in fact and indeed consider the matters that is advocating and canvassing as exceptional circumstances.
Okay. I mean, so, Martin Kpebu, so you've seen his basis. The exceptional circumstances which have resulted in a miscarriage of justice is one. Second, discovery of new and important matter or evidence, which, after the exercise of the due diligence, was not within the applicant's knowledge or could not be produced by him at the time when his decision was taken. What's your take there on what you've heard, if you put it against what the rules say?
You know, we are restricted by the rules that we use in court. I mean, generally, they decided cases that we can't go into the merits of his application so that we don't catch contempt of court. So basically, I can only comment based on previous cases. As Honorable Yunus Afsini stated, the reviewed jurisdiction is quite a tall order. Very, very, very tall. Yeah, so from the data, the cases, the reported cases, not even up to 10% of them succeed. Yes, so it's really, really a tall order. Yeah, because sometimes the court will even tell you, there are some of the cases where they say, oh, if the fact that they've made a mistake by itself it's not even sufficient grounds to grant a review application. Yes, the Supreme Court, you see it there. And it's not only in Ghana. Of course, we take inspiration from the English cases. Yeah, you find it there. So mistakes have, so for the purposes of this, what do you call it, program, let me say, there are categories of mistakes. So there can be a minor one and a major one, and maybe something in between, like different shades of gray, right?
Yeah.
Yeah, so a mistake by itself is not even sufficient to for the court to grant a review application. It all depends. It's such a weighty jurisdiction that, as I've said, from the decided cases, not up to 10% of the review applications have succeeded. 10 is actually putting it high, maybe 5%, not even up to 5%. Yeah, there are few, rare, actually I should be using the word very rare, that a review application succeeds. But then, as I've said, I'm talking about data in the past. Anything can change, okay? The court can look at it, especially as citizens have railed and railed about the judgment that it doesn't bode well for our democracy. It's possible the judges listen, they are also citizens, so sometimes they can look at it. And of course, within the law, there will be enough space for them to then reverse course, as you say, to reverse the judgment.
I mean, but let me ask you this. I mean, looking at how very controversial, this is a big matter of national conversation. Is it worth pursuing a review? Seeing that what you just told us about the likelihood of success, if you look at the past experience being very slim, is it an adventure that is worth pursuing still?
Yes, because he just has to go all the 9 yards. Once he started it, he has to, so that posterity will not judge him wrongly and say, oh no, we think there were grounds for review, yet he didn't pursue. So he just has to finish it. But that's not the end of the conversation. You know, Honorable Haruna Iddrisu and co have started a new action.
Yes.
Which indirectly may have the same effect, depending on how it is argued and the rest. So Justice Abdullahi's case is not the end of the conversation, and I don't even expect that Honorable Haruna will be the end. Of course, by saying that's not the end, people will attempt, okay? But it's up to the Supreme Court to look at it and say, no, we will no longer give any listening ear to these applications. Okay, that's to say, or this kind of rate, anything challenging the power of the Deputy Speaker to vote whilst presiding. So it's a problem, but somehow I'm sure what I always find is level.
Okay, yeah. and just quick guide through this. And Ms. Abdullah, I'll come to you shortly. Quick guide through. So normally in a review cases, what happens? Must the CJ empanel a whole group of judges, or the same old judges with some additional ones? What works?
Excellent. The old panel plus 2. So if there were 7 plus 2, you get 9. If there were 9 plus 2, you get 11. Yes. But
that's interesting. I mean, for mere mortals like us, if the 7 were unanimous before, you add 2. Best case scenario, you only get 7-2.
You're just putting the question so I can answer.
And you still lose the case.
Sometimes they just change their minds. There is a popular case. If you look at Amidou, let's use the ones that are known to the public. At least the last time such a big one succeeded. Martin Amidou versus Woyome. You know, the ordinary bench said the Supreme Court couldn't make orders for the recovery of the money in the Supreme Court. That he should go to the High Court and start a new action. And he came on review. The court looked at it and said, oh, no, they think that they made a mistake, and so they will make orders that Mr. Woyome should refund the money in the Supreme Court. Yes, I think as far as I can remember, that was the last time a major review application succeeded, right? So you see, we still come back to the fact that the successful ones are very rare, okay? Yes, so that's an example. There are a few other ones. You see this matter of sometimes you go to court, you know, we all make mistakes. Sometimes you go to court, you forget to ask for some reliefs, certain things from the court, but then you have led evidence. So they look at it and say, oh, so let's say, Evans, you went to court, you said they should give you, somebody is taking your car, and let's say your furniture from your room. So you've spoken about, you said the court should return the car to you, but you forgot to mention that they should return the furniture. Yet in the evidence before the court, you've described how the person also took your furniture and all that. So if the evidence is very clear, you don't need to go and start a fresh action. They can make an order that the furniture to be returned to you, though you didn't ask for its return when you were typing what we call the reliefs. What specifically do you want the court to do? You failed to state that return of my furniture. Yet in the evidence, you said everything that has to be said about your furniture and how you want it back. Yes, that one, they granted it. Yeah, it's called Anaisi versus Gihog Distilleries. That's about 2007, 2008. Yes. So you see, very, very rare occasions on which the review jurisdiction or review application succeeds.
Mr. Hussein, what's your comment on that? I mean, I'm fascinated by the process. 7-0, and they add 2 people to it. I mean, isn't that almost setting what the outcome possibly could be? I mean, and this is a tall order.
First of all, that is how the court system is structured. So the High Court, you have 1 judge presiding. And in the Court of Appeal, we have 3. So there's wisdom in numbers. And in the ordinary bench, you have 5, 7, 9, 11. So, I mean, this is how it is structured. We believe that there is wisdom in numbers, and that for instance, in the Court of Appeal, if 3 judges determine the matter in a way that you feel that the way they determined it was not satisfactory, and you appeal to the Supreme Court, the number increases. You don't have 3, you have 5 going. So clearly, I mean, the way the court system is structured gives some comfort that you can have a decision change or reversed. Now, but the review jurisdiction is a special kind of jurisdiction. I mean, the court have repeatedly said that the review jurisdiction is not an appeal jurisdiction. The fact that you have lost a case does not entitle you in the Supreme Court to appeal against the decision. The appellate jurisdiction of the Supreme Court is exercised on matters emanating from the Court of Appeal. And so you cannot appeal against a decision of the Supreme Court. And because of that, the court has set stringent rules, very, very stringent rules to regulate the exercise of that review jurisdiction. Now, yes, like Martin said, even in situations, and I've had exchanged information with Justice Abdullahi, but even in situations where the court is convinced that they have, not had the benefit of other legislation, to put it that way, they will have to answer to the second leg. So if we say there are exceptional circumstances, or there were matters that were not available, and that if they were available, the decision would have turned in another way. Or if we say the exceptional circumstances of the case will lead to a miscarriage of justice. So you have the exceptional circumstances, yes, so you demonstrate those exceptional circumstances. You also have a responsibility, an obligation to demonstrate how that will lead to a miscarriage of justice. You have to couple it. And so, well, like I said from the beginning, Justice Abdullahi is exhausting the options. And Mata Kwewo has said that, yes, the matter of whether or not the first deputy speaker or second deputy speaker can vote, if the processes are exhausted, because litigation must have an end, and the review jurisdiction of the court invoked and a pronouncement on that matter, that particular issue, will become issue estoppel. You can't bring it again because it's finished. It's finished. That issue has been dealt with, and that is the law. Unless
of course, another matter comes tangential to that issue. But whether or not a first deputy speaker or a second deputy speaker or any member of parliament presiding can vote, after the review jurisdiction and the pronouncement of the court, that issue will be stopped. You cannot litigate that issue again. That issue is gone. The Supreme Court has decided it this way. And so I believe that because of that, and like Martin Kpebu said, because of that, Justice Abdullahi will be remiss if he feels strongly that the Supreme Court erred in not taking into consideration certain aspects. I have said that, for instance, the striking down of Order 1093.
Yeah.
Yes. So I have had discussions with Justice Abdullahi on that. What does it mean? What is the standing orders? What is the definition of the standing orders within the contemplation of the Constitution, and especially Article 295? Okay, can the hands of the Supreme Court stretch to the standing orders within the definition of Article 295? Okay, that is the interpretation column of the Constitution. So we need to clear all those matters, and when finally the court pronounces, we can all go to sleep.
I mean, Justice Abdullahi, so you've had it. I mean, this is a tall order. Very, very rare. What's your confidence level?
Evans, absolutely fantastic analysis by my senior friends. They are on point. It is a very difficult hurdle that I would have to surmount. I am not in doubt at all how it appears impossible. Indeed, some described it as the ratio of maybe 1:100, and I agree. I have no doubt at all about it. I am not in some fanciful doubt about some of these matters. But I do believe, however, that the Supreme Court is a court of wisdom, it's a court of law, it's a court of logic and reasoning. It's not a court of mathematics. I believe that if they find favor with my argument, perhaps, just perhaps, they may have the occasion to review, grant the application and possibly make the necessary orders. However, we should understand from this, as my senior brother Yusuf Seni said, it is for the principle. We may go and come back with the same position, but what that would mean is that there will be complete finality to this whole argument. And that is good for all of us. It is rather unfortunate if you leave it the way it is now, and the way it has rather deepened the polarization of our political discourse, and leave that lingering question as to whether the Supreme Court would possibly have taken a further bold decision to either demystify or reevaluate the position that they made. That would remain a question that we would not be able to answer if this decision is not taken. And so this is important for all of us, for us to at least on the basis of the principle to accept that this is the position, and until a new decision comes before the Supreme Court, that they probably may take advantage to review or to make further orders in regards to this Justice Abdullahi as Attorney General, we may have to embrace what we have at the moment. And so let's all understand that it's not a walk in the park. It's not going to be that simple or easy. It's something that is going to be very difficult, and I admit this fact. And I'm not in any shade of doubt at all about the difficulties.
Do you accept that this is, as some have said, an exercise in futility?
That I do not agree.
Okay.
That is prejudicing this whole application and prejudging the outcome of it. Okay. I think that part of it is not healthy for all of us. It's not healthy for the Supreme Court. I think we should respect the Supreme Court to be able to change their mind. We should accord them that level of respect, that they are capable of changing their minds when a reasoned argument is made before them. They have that ability. They are not robots. They are human beings, and these are very intelligent lawyers who have become Supreme Court judges. And so if you make a strong case before them, I have every faith that they would listen to it and then maybe give you a positive answer.
Yeah, I mean,
for good reasons, sometimes they do not do that, for good reasons.
Okay.
But it is not to say that they will not do it at every point in time.
Martin Kpebu made a point I need to put to you. I mean, you know, the Haruna Iddrisu, Mahama Yarega, and one other person have gone back to the Supreme Court for...
I believe that's Okudzeto Ablakwa.
Exactly. On the back of the, fortified by the same verdict of the Supreme Court to affirm a position that they're taking. How will that affect your review?
Yes, that their case is grounded on the existing law, i.e. Justice Abdullahi versus Attorney General. And that has not been heard yet. There's no pronouncement on that yet. As a matter of fact, my review rather has the potential of affecting this.
Yes, okay.
If you notice, I think it was Richard Sky. He also had a writ on similar grounds, and the Supreme Court had to throw it out because they felt that
it was moot. It was moot.
Exactly.
Yeah.
So it is the same way that except that in this particular case, the Haruna Iddrisu versus Attorney General is rather relying on Justice Abdullahi versus Attorney General to make their case. And so it is the reason why a review application may impact positively on this or adversely, depending on how the review goes.
You're right. I mean, if you win this review, in essence, will mean that the status quo before will return, right? And
that is not 100% correct, though.
Okay.
Because a grant of a review may not necessarily bring back the status quo. It could bring something completely different.
Okay. Okay.
Something completely different. But of course, the expectation is that it brings back it rather brings back my relief. That is what it is.
Okay.
It is not to bring back the status quo. It is the relief that I was seeking.
Which is that the Speaker while presiding cannot vote, the decision
Absolutely.
in November to approve the budget, it's invalid, and the third one.
Thank you. So essentially, the quorum and then the voting right.
Yeah.
So these are part of the relief that I was seeking. Now, those two automatically affects the validity of the budget as approved.
Yeah.
Of course, the Supreme Court still has a right to make consequential orders regarding the approval or otherwise of the budget. They can still admit my review and grant my reliefs without necessarily adding that consequential order because, of course, we've moved on. So they have the right to make those decisions. So my point remains that if my reliefs are granted, it will still impact the Innocence of Senate case, but in a way that we may not be able to project today, because we do not know the extent to which...
I must say, though, that if you read the judgment, there are two most controversial things in there. One, obviously, is what the fact that the presiding, the Speaker acting can vote. But the other one, which has really got Parliament really divided, caused a lot of trouble on the floor, it's the distinction the Supreme Court created between voting quorum and non-voting quorum, and what that is, which is really the basis of Haruna Iddrisu and Cole's decision, to the Supreme Court. Mr. Inus Afuseni, that voting quorum and non-voting quorum distinction, which really comes down to numbers, I wonder, and which is really the subject of this controversy on the back of the decision to pass the e-levy, either you are doing 138 or 137, whatever it is. I mean, is there a hope or possibility that this review could further elucidate on that particular matter, which of course is a subject of another attempt to get some clarity by Inus Afuseni, Haruna Iddrisu and Co.
Yes, I should think so. I should think because the judgment in Justice Abdullahi's case has evoked a lot of controversy, has got people talking. I believe that is one such reason why the National Security Minister spoke. I mean, that has got people talking.
Yes.
And so the court might take the opportunity to clarify certain things in the judgment. Okay. That's what I believe. Secondly, there have never been an issue between Article 102 and Article 104. Article 102 is quorum for business. So it says you must be 1/3 in the House.
Yeah.
That works out to 92. So when you get into the House and start votes and proceedings and do the correction of the votes and all that, prayer, correction of votes, the next thing, before you go to commencement of public business, if you are not up to 92, someone can raise a matter of quorum. In my 15 or so years in Parliament, it has to take somebody to raise quorum if you are not 92 in the House for the House to adjourn. And you could recall that Speaker Michael Quay repeatedly had to adjourn the House because at the commencement of business, public business, we didn't have the numbers.
Yeah.
Now, 104 is a different quorum altogether. It says, look, you can have 92 in the House. You can even have 130 in the House. You can debate and conduct business, but you cannot vote to take a decision unless you are half in the House. That's 92. We didn't used to call it voting quorum. We just, when we were in Parliament, anytime there was a controversial matter, and there were many controversial matters which the Article 104 was referred to. Anytime there was a controversial issue, we thought that we needed more discussions on the matter. And the Speaker was bent on putting the question. Someone will arrest the question by invoking Article 104 and drawing the Speaker's attention to the fact that we didn't have the numbers. That's what we used to say. We didn't have the numbers to take the decision. We didn't used to say we didn't have the voting quorum. And the Supreme Court and Ketse Yoni-Kolende, who's given us that lexicon. You see, so now we say voting quorum. But we used to say that we didn't have the required numbers under Article 104 to take a decision. And so the Speaker will adjourn the taking of the decision to another day, hoping that on the next adjourned date, we'll have the numbers to take the decision. Then we don't really debate the matter, we'll just vote on the matter, and that ends it. So there are two different things. Now, so Haruna Iddrisu's case, the Speaker, the Supreme Court, in analyzing the voting quorum, made a statement of what the quorum is.
Yeah.
Okay, so now that statement, that pronouncement of the Supreme Court is the basis of the action of Haruna Iddrisu and two others. That the Supreme Court haven't determined that the voting quorum should be 138. Okay, majority of which must take that decision. If in Parliament at any given time, the number is not 138, then Parliament itself is incapacitated, doesn't have that capacity legally and constitutionally to take that decision. And so they're urging the Supreme Court to rely on their own pronouncements in the Justice Abdullah case to declare what Parliament did recently as a nullity, because they are 137 in the House. They were not in the House. One other member of the majority side was not in the House. And so there was no way they could be 138. So sometimes I call it mathematical logic. The Justice Abdullah has also referred to the numbers thing. Well, so we are waiting to see whether in this particular case, the Supreme Court would uphold their argument, or the Supreme Court will now find an appropriate basis to say that this is a political question.
Yeah, and then
what happens?
And really, what you just pointed out is it just shows the pressure, I guess. I mean, and these are judges who are very experienced, but these matters recently, the way it's become very, very controversial, would definitely become one of those issues that the Supreme Court judges will have to, whichever way they rule, they're going to be a little spotlight. And I want to bring up something you said. It is in the context of that the National Security Minister was just speaking recently and made some pronouncements about the conduct of the court. And it has become a subject of some very intense debate. In fact, today, we've had two senior members of the NPP criticize the National Security Minister for making these pronouncements. So what did he really say? Watch him.
Justice occasioned as a result of the absence of an effective justice delivery system, or delayed justice, or biased justice, is certainly a threat to national security. If you do not have a system, a judicial system that works, many people will simply take the laws into their own hands and misbehave and do what they want. Therefore, in trying to manage the security situation, it is important for us that we do get a judicial system that works. If the interpretation of the law is tilted so much in our favor all the time, people will start accusing the judiciary and will not have the confidence that they need.
Let me start with you on this, Martin Kpebu. That last comment he passed is what has caused a lot of controversy. That if the interpretation of the judgments appears to be skewed towards us all the time, and us by us, you mean possibly the MPP government or the government itself, then people will begin to have trust issues with the judiciary. What do you make of that comment?
Evans, listening to and watching Mr. Kandapa, I think instantly I'm seeing a different angle to this case. Mm-hmm. That's to say the debate. So that's an example he's giving. But what I read in the media and what I'm hearing, it was made to appear that he was saying that what the judges have done. So you see, he's saying if. Yeah. So it's conditional. I think what I'm hearing around is as if he's totally concluded that all the judgments that were given, they were unjustified, sort of. So the judges should distribute. But if he said if, that one, he's making a point. And that area is common knowledge that, yes, if such a thing happens, certainly people will lose hope in the judiciary. So what I'm saying is that in terms of his sentence, unless I didn't hear him well, I heard if and the rest. Yes. So that's a statement he can make. He's making the point hypothetically. So the single word I see him doing is that he's talking about hypothetical situation. You say, but it's been taken as if he was especially berating them for giving judgments. Though, yes, we are saying that, yes, you would seem to see judgments going in a certain direction. But it doesn't appear that's what specifically. You see, I want to stick with the words. It doesn't appear that's what he's specifically addressing. He's talking about hypothetical situation. And then, you know how news, you filter things for us. So somebody's drawing it, that he's talking about what is on the ground. But I think to be fair to him, if he wanted to talk about what is on the ground, he wouldn't be using if. Do you say it? Yeah. So I really, from the little that I've just...
very quickly, so I can bring in Mr. Fuseni. So when Frank Davis, who's the chairman of the MPP legal team tonight, was criticizing him, his point is that when the National Security Minister says, if the interpretation of the judgments is that you are being skewed towards us all the time, then people will begin to not trust you. His point is that that comment was ill-advised and inappropriate because it seemed to suggest, so what is wrong if the judges rule all the time in favor of the government because the evidence points to that?
No, it cannot happen. There certainly will be something wrong because, Evans, let me tell you something. In law, a lot of the time, there is no correct and wrong answer. Evans, trust me, in law, a lot of the time, there is no correct and wrong answer. Actually, it's about perspectives. You heard me say different shades of gray. Yeah. So it depends on the experiences and the views of the judge. If it's conservative, like let me take specific example, marriage. You cohabit with a woman. You haven't performed the customary rites, and you know they may not cost much. But once you haven't performed that, you can live with her 40, 50 years. One judge will tell you that he doesn't see marriage. Another judge looking at it will say, oh, yes, I don't see a formal marriage, but I see an informal marriage. You hear Mpana.
Yeah.
So it all depends, and I can give you 1,001 examples.
So you say that if the scenario he creates is what happens, then there's definitely an issue. That he has a point there. That if all the cases are in favor of the government, then there should be an issue. Okay.
Oh, that one nobody can debate.
Mr. Fuseni, I have a few seconds. Mr. Fuseni, give me a quick bite on this.
Well, you see, this is a continuing debate. It's a continuing. Raymond Atuga conducted a research which showed that justices appointed by a particular government voted a particular way. The research findings were so overwhelming that you would have come to the one conclusion, that if a Supreme Court is empaneled by a set of judges appointed by one government, their decision might tilt towards the government. Now, the former director of the Ghana Law School also made a similar pronouncement on your network, PM Express. You recall?
Yeah.
Yes, he said, look, he knows what happens. He has been a director of the School of Law, and he knows what happens, and that justices appointed by a particular government to the line of the government. He said it on your network. I see what what Honorable Kandapa has said to be a continuation of the debate. But Kandapa, speaking as a national security minister, was drawing attention to the security implications of such a perception.
Yeah.
Okay. I have a fundamental difficulty studying law at the law faculty, and I was there with Martin Pebo. We knew that where a decision of the Supreme Court was given, justices, even if they had nothing to add, will just state, I agree.
Yeah.
Sometimes they agree, but on different sets of conclusions. But they agree totally with the decision. Now, here we have in the in the Justice Abdullahi case and the Attorney General, all the judges apart from Yuli Kune, they just signed. What did they sign to? What did they sign to?
That they agree.
No judge said that he had agreed with the decision. But the practice, as I know it, has been that justice must indicate their position on the matter.
Okay.
But you see, so clearly, is it a new form of jurisprudence that is emerging, that judges do not need to indicate anything on a judgment delivered by the Supreme Court, because all the judges, like Martin Pebo said, it is the idiosyncrasies of the judges, which is the law.
Mr. Fuseni, thank you very much. Unfortunately, we ran out of time on this. Justice Abdullahi, I want to wish you all the best in this endeavor. Enjoy the rest of your evening, gentlemen.
Thank you so much, Evans.